Something massive just happened in Canada, and if you own a firearm, live in any of the 10 provinces, or simply believe that the law should mean something consistent from coast to coast, you need to stop whatever you are doing right now and watch this video to the very end. The Supreme Court of Canada has just issued a ruling so sweeping, so unexpected, and so fundamentally disruptive to the existing legal framework around gun rights in this country that provincial governments are scrambling behind closed doors, legal teams are working through the night, and millions of Canadians are waking up to a reality they were never prepared for. This is not a drill. This is not a slow-moving policy debate. This is an emergency decision that landed like a shockwave across every corner of this nation, and the aftershocks are only beginning. If you are new to this channel, welcome, and please hit that subscribe button right now, because what we cover here is exactly this. The real news, the decisions that actually reshape your daily life in Canada, explained clearly and without spin. Hit the bell icon too, so you never miss a breakdown like this one. Now let us get into exactly what happened, why it matters, and what every single Canadian needs to understand before this week is out. To understand the full weight of what the Supreme Court of Canada just did, you have to understand the landscape it was operating in. For years, the federal government, under successive administrations, has been tightening the screws on firearms legislation in Canada. Bills were passed, regulations were updated, entire categories of firearms were reclassified overnight by order in council without a vote in Parliament. Canadians who had legally purchased, legally stored, and legally used their firearms for decades suddenly found themselves holding property that had been reclassified as prohibited, not because they had done anything wrong, not because any crime had been committed, but because a cabinet decision had redrawn the legal lines around them. That tension had been building for years, and it finally reached the nation's highest court. The case that triggered this ruling involved a coalition of licensed firearms owners, sporting associations, and several provincial governments who challenged the constitutional validity of key provisions in federal firearms legislation, specifically around the authority of the federal cabinet to unilaterally reclassify firearms without going through Parliament, and around the question of whether certain gun control measures intruded on provincial jurisdiction over property and civil rights under Section 92 of the Constitution Act. The argument was not simply about guns, it was about the fundamental division of powers in a federation, about whether Ottawa can reach into the daily lives of Canadians on matters that touch provincial authority, and about whether property rights have any meaningful protection in this country's constitutional order. The Supreme Court, in a majority decision that stunned both sides of this debate, ruled that the federal government had overstepped. The court found that the use of order in council reclassifications to bypass parliamentary debate on major firearms policy changes violated the constitutional principle that significant alterations to the rights and obligations of citizens require the full legislative process. This is historic. This is the kind of ruling that gets cited in law school classrooms for the next 50 years. And if you think this only affects people who own guns, you are about to understand why that assumption is completely wrong. This ruling is historic for reasons that go far deeper than firearms policy, and that is what so many people in the mainstream coverage are missing right now. What the Supreme Court has effectively done is draw a hard line around executive overreach in Canada. The government's ability to use cabinet orders to make sweeping changes to the legal status of property held by millions of Canadians has just been constitutionally constrained in a way it never formally was before. Legal scholars on all sides of the political spectrum are already calling this one of the most significant rulings on the division of powers in a generation. But let us talk specifically about what this means for gun rights, because the implications are enormous and they run in multiple directions at once. First, every firearm that was reclassified from restricted or non-restricted to prohibited through order in council since the most recent wave of reclassifications began is now under direct legal challenge. The court's ruling creates the constitutional basis for owners of those firearms to seek relief, and several legal organizations have already announced they will be filing applications on behalf of their members. This changes everything for the estimated hundreds of thousands of Canadians who were told their legally purchased property was suddenly prohibited and that they would need to hand it over or face criminal consequences. Second, the ruling opens a genuine constitutional corridor for provincial governments to assert greater authority over how firearms laws are administered and enforced within their borders. The court acknowledged, in language that was careful but unmistakable, that provincial jurisdiction over property and civil rights is a meaningful constitutional constraint on how far federal firearms policy can reach. That is a door that had been functionally closed for decades, and it is now open. All provinces are now on high alert because every provincial attorney general in the country is reading this decision line by line to understand what it gives them and what it takes away. Third, and this is where things get politically explosive, the ruling does not strike down the core of federal gun control authority. Ottawa still has jurisdiction over criminal law, and that includes the broad framework of the Firearms Act. What the court has done is constrain the method, not the entire mission. The federal government can still pursue firearms policy, but it must do so through Parliament, through debate, through the full democratic legislative process, not through the back door of cabinet orders. That distinction is going to fuel a ferocious political battle in Ottawa over the coming months, and every Canadian is going to feel the turbulence. Now let us go province by province, because the impact of this ruling is not uniform across Canada, and where you live is going to shape how dramatically this decision reshapes your day-to-day reality. In Alberta, this ruling is being received as a vindication of years of pushback against federal firearms overreach. The Alberta government had already been among the most vocal critics of unilateral reclassifications, and provincial officials there are already signaling that they intend to use this ruling as legal and political leverage to resist future federal firearms measures that they argue intrude on provincial jurisdiction. For Albertan gun owners, this feels like the first real institutional win in a very long time. In Saskatchewan, the reaction is similar. The provincial government there had actually been a party to or a supporter of constitutional challenges in this space before, and they are now in a strong position to shape how this ruling gets implemented within their borders. Rural communities across Saskatchewan, where firearms ownership is deeply tied to agriculture, pest control, and cultural tradition, are watching this decision closely and with cautious optimism. In British Columbia and Ontario, the picture is more complicated. Both provinces have large urban populations where the political conversation around firearms tends to skew towards stricter control, and both provincial governments have been broadly aligned with federal firearms policy in recent years. For these provinces, this ruling is not a celebration. It is a complication. It forces their governments to navigate between a federal partner whose approach has just been constitutionally constrained and a segment of their own provincial population, particularly in rural and northern regions, who have been deeply aggrieved by recent reclassifications. Quebec occupies its own unique position in this conversation, as it often does. Quebec has historically been more supportive of strict firearms regulation, and the province has its own complex history with gun control that includes the long shadow of the 1989 Polytechnique tragedy. For Quebec, this ruling raises difficult questions about how the province can continue to pursue its own firearms policy preferences within a constitutional framework that has just been partially redrawn by the nation's highest court. In Manitoba and the Atlantic provinces, New Brunswick, Nova Scotia, Prince Edward Island, and Newfoundland and Labrador, there is a mixture of reactions that reflects the diversity of these communities. Rural gun owners and hunting communities in these provinces have long felt that federal firearms policy was written by and for urban populations who have little understanding of how firearms are actually used and depended upon outside major city centers. This ruling, for many of them, represents the first time they feel the legal system has genuinely heard their concerns. In the three territories, Yukon, the Northwest Territories, and Nunavut, the stakes are arguably the highest of anywhere in the country. In these communities, firearms are not a political symbol. They are a survival tool, a means of food security, a part of indigenous cultural practice that predates Confederation by thousands of years. The tension between federal firearms regulation and the realities of life in the Canadian North has always been acute, and the Supreme Court's ruling has now inserted itself directly into that tension. And if you are watching this and you want to tell us where you are in Canada, drop your province or territory in the comments right now. We want to know how this ruling is landing in your community, and we are reading every single comment this week. Now let us talk about the reactions on the ground, because this is where the human reality of this decision becomes undeniable. Gun owners who had their property reclassified, people who woke up one morning to find that a firearm they had owned legally for 20 years was now prohibited, are describing this ruling with a kind of emotional intensity that is difficult to overstate. Some are calling it the moment they stopped feeling like criminals in their own homes. Others are cautious, noting that the legal process from this ruling to any actual change in their situation will be long and uncertain. But the sense that the highest court in the land has acknowledged that something went wrong, that the process was constitutionally flawed, is meaningful to these people in a way that goes beyond policy. Provincial governments, as we discussed, are reacting based on their own political alignments and constituencies. But even in provinces that have supported stricter gun control, there is a recognition among serious legal and political advisors that this ruling cannot simply be dismissed. It is a Supreme Court majority decision. It is binding, and it creates obligations and opportunities that every provincial government has to grapple with, regardless of its preferences. Legal experts are divided on the long-term implications, but united in their assessment that this is major. Constitutional lawyers who specialize in the division of powers are saying this ruling will be litigated and interpreted for years. Firearms law specialists are already mapping out the legal strategies available to affected gun owners. Civil liberties advocates from across the political spectrum are pointing to the ruling's broader implications for executive authority and the rights of property holders. This is not a fringe conversation. This is the mainstream legal community taking a very significant decision extremely seriously. So, what do you actually do right now if you are a Canadian who is affected by this ruling? The first thing you need to do is get informed. This script is a starting point, not a legal consultation. If you own firearms that were reclassified under an order in council in recent years, you need to connect with a licensed firearms legal specialist or one of the national firearms associations that are already organizing around this decision. Do not make any decisions about your firearms or your compliance obligations based on social media alone. The legal landscape is shifting rapidly, and you need accurate, current, professional guidance. The second thing you need to do is contact your provincial representative. This ruling gives provincial governments real constitutional leverage, but they will only use it if they hear from their constituents that it matters. Whether you are in a province that is inclined to push back against federal overreach or one that has been more aligned with Ottawa on firearms policy, your voice as a voter and a citizen has weight right now. Make it heard. Write the letter. Make the phone call. Attend the town hall. The political decisions that get made in the next 60 to 90 days in the wake of this ruling are going to shape how this decision actually lands in your life, and those decisions will be made with or without your input. Third, if you are a member of a hunting club, a shooting sports association, a rural community organization, or any group that has been affected by recent firearms reclassifications, now is the time to coordinate. The legal and political opportunities created by this ruling are real, but they require organized, sustained engagement to be realized. Individual voices matter, but collective voices move governments and courts. Get organized, stay organized, and make sure your organization is connected to the national level legal and advocacy efforts that are already underway. And if you are someone who has not been directly affected by firearms reclassifications, but you care about executive overreach, about the proper functioning of Canadian democracy, about the principle that major changes to the rights and obligations of citizens should go through Parliament and not around it, then this ruling matters to you too. because the constitutional principle the Supreme Court has affirmed today does not stop applying at the edge of gun policy. It applies to any area where a future government might be tempted to use cabinet orders to bypass democratic debate. This ruling is a guardrail for Canadian democracy, and every Canadian has a stake in making sure it holds. Here is the final warning you need to hear before this video ends. The federal government is not going to accept this ruling quietly. There are already signals from Ottawa that the government intends to respond through legislation, to pursue the same policy goals through the parliamentary process that the court has now required. That legislative battle is coming, and it is going to be fierce. There will be pressure, there will be lobbying, there will be media campaigns. The forces that pushed for aggressive reclassification through cabinet orders are not going away. They are regrouping. The window created by this ruling for Canadian gun owners and for the provinces that want to push back is real, but it is not permanent. It requires immediate, sustained, organized action to be anything more than a temporary constitutional moment that gets legislated around within the next parliamentary session. The Supreme Court has spoken, the provinces are reacting, the gun owners are mobilizing, and Canada is standing at a constitutional crossroads that will define the relationship between citizens and their government, between federal and provincial authority, and between property rights and executive power for the next generation. This changes everything, but only if Canadians engage with it like it does. If this video gave you clarity, hit that like button right now because it tells us to keep making content like this. Share this video with every Canadian you know who needs to understand what just happened. Subscribe to this channel because we are going to be covering every development in this story as it unfolds, including the federal government's legislative response, the provincial reactions, and the legal challenges that are already being organized. Turn on notifications so you do not miss a single update, and drop your province or territory in the comments below. We want to build a map of how this ruling is landing across the country. Canada just changed. Make sure you are ready for what comes next.